As in this case, where this dashcam video may be strong enough evidence to gain a conviction even without any statements from the defendant that she only drank 2 beers. The ultimate decision on this case and others like it will play out in a courtroom like this one. The prosecutor is on one side and will present the case to the court. The defense attorney is on the other side, ready to defend his or her client. The case may be heard by a jury or by the judge him or herself.
Ordinarily, any case involving due process issues or liberty issues, in other words, criminal cases where someone could go off to jail or prison, that person is entitled to a trial by a jury of their peers.
However, cases heard in juvenile court, family court, and probate court are the exceptions to that rule. In cases where a jury is impaneled, the judge sets the ground rules.
Now, the judge, in applying the law, will determine what testimony and evidence the jury will see and hear. Some of it may be admissible, some of it may not. So the judge in that case rules on issues related to the law, which determines what the jury sees and hears. The jury then determines the outcome, guilty or not guilty, based upon the facts as they find them.
In capital cases where someone could be subjected to the death penalty, juries consist of 12 members. But most cases would be tried before a 6-member jury.
And the 6-person jury is picked randomly. Ordinarily, a judge will ask for at least one alternate juror. An alternate juror is someone who sits with the jurors as if he or she was a regular juror. Ordinarily, the alternate doesn't know that he or she is the alternate. If the case reaches a conclusion and the jury begins to deliberate and we still have all 6 of the original jurors, the alternate is excused at that time.
If one juror becomes ill during trial, the alternate can fill in because they've all listened to all the testimony. But no matter the size of the jury, the judge presides over the case, makes decisions regarding the law, must be fair and impartial, and must be a good listener and good communicator in considering everyone's position.
Because usually, in most cases, people disagree on what the facts are. People disagree on what the outcome should be. And when a judge is asked to decide what that outcome should be, it's easy for the side that feels that they have lost to think, well, that judge had his mind made up or her mind made up, or the system's not fair because I didn't get to present all of my testimony or evidence.
The prosecutor presents testimony or evidence on behalf of the state. It is the prosecutor's responsibility to seek justice, not just get a conviction. The prosecutor decides what charges to file, if any. The prosecutor may offer a plea bargain before going to trial. And once at trial, the prosecutor needs to prove the charges beyond a reasonable doubt.
We have an ethical duty to only take cases to trial and to only proceed on cases where there's a reasonable likelihood of a successful prosecution. If the facts and circumstances do not meet that level, and when the state can't prove the charges beyond a reasonable doubt, justice in that particular instance would then be to drop the charges.
Under our system of law, the defendant, in this case the young woman accused of drunk driving, always has the opportunity to defend themselves, usually with the assistance of a defense attorney.
And really what we do is we help negotiate, we help guide people through the criminal justice system. A lot of people have never been involved with it before, and it's very confusing, it's very scary. You're dealing with law enforcement, you're dealing with a prosecutor, you're dealing with a judge, perhaps a jury of your peers, and it's a very scary situation. Most times, it's the absolute worst thing that's ever happened to someone.
The defense attorney guides defendants through the legal system, has an open mind and must be objective, helps negotiate plea bargains before going to trial, challenges evidence and/or testimony at trial, and has their client's best interests at heart.
Because the criminal justice system does not work without defense lawyers like me. Nobody wants a guilty person to go free. And I'll tell you, it doesn't really happen that often. But no one wants an innocent person to go to jail. And so what I do is I make sure that everything was done right, that I review the facts with my client, I make sure that the police did not violate my client's constitutional rights.
That means police did not take the statement illegally. They didn't obtain evidence improperly. They didn't plant any evidence. In fact, they did everything appropriately. But surprisingly, very few cases actually go to trial. The majority of cases are resolved by a plea or some sort of negotiation.
It's very easy to point the finger and be a prosecutor, and it's very challenging to defend. And a lot of people look at the defense attorney as wearing the black hat, but that's not my opinion. I feel that I really am the last defense of the Constitution to make sure that everything was done right.
There is a certainty in our judicial system that everyone makes mistakes despite their best intentions. And that's why our legal system has an appeals process.
Appellate judges don't try cases. They don't take testimony or evidence. What they do is they will review the record from a lower court or a trial court, and they'll hear arguments of the attorneys on both sides who will brief the courts, and that's where the term brief comes from, to tell them, yes, they think the court below committed a legal error that should result in a different outcome, or, of course, if you prevailed in the lower court, you'll say, no, everything was fine.
If the appellate court finds an error in the trial, it can send the case back to the trial court or reverse the decision of the trial court. But the legal system is not limited to criminal courts. It also encompasses civil courts, where anyone can sue for damage or negligence. Family courts that determine custody, visitation, support, and paternity decisions. Probate courts that deal with claims on estates. And juvenile courts that deal with dependency and delinquency. The legal system is part of our judiciary system, which is one of the three branches of our government. The other two are the legislative branch, which consists of the House of Representatives and the Senate, and the executive branch, which consists of the President, Vice President, and members of the Cabinet.
If we didn't have the legal system, we wouldn't have a way to resolve our disputes peacefully. And you've seen in other countries, when disputes cannot be resolved peacefully, what happens? You've seen what happens to governments when elections are challenged and people can't find a legal way to resolve disputes. If we didn't have a legal system that did that on the big issues and all the way down to the small issues, people would have no recourse other than to take the law into their own hands. And we know how well that works or doesn't work.
Do you not recall handing it to me?
Are they able to understand instructions? Are they able to have a conversation with the officer? If the officer asks for their driver's license, do they respond appropriately?
How much did you have to drink tonight?
Oh my God. Oh my God. I'm getting arrested. Oh my God.
All right, good afternoon. It's nice to be with you live. You had a chance to see me on video. My name's Peter Block. I'm the Chief Judge here in the 15th Circuit, which is Palm Beach County. And I'm here to answer any questions you have after having the opportunity to see that video and the information it provided. So let's get right to it. Who has a question? Yes, ma'am.
Your Honor, why is it that in some cases in the arrest, Miranda rights aren't immediately read upon the arrest?
As opposed to other times when they are not? If an officer believes, or a detective, whoever is the arresting agent, believes that they're immediately going to make inquiry of a suspect upon arrest, then it's important that they read the Miranda rights at that time, because they want to make sure that if any incriminating statements are made, they'll be able to use it later on. If there's not an intention to inquire or question a suspect, then it's not critical at that point in time. And if they decide later on to interrogate a suspect or ask questions, then they'll read the Miranda rights at that time.